In today's video, I'm going to talk to you about common outcomes of shoplifting charges in Florida. My name's Adam Rossen, and I'm the owner and founder of the Rossen Law Firm. We're a team of criminal and white-collar defense attorneys in South Florida. I'm a former prosecutor, and me and my team, we've handled hundreds, if not thousands, of these type of cases, and we have over 600 five-star reviews on Google and all over the internet. And by the end of this video, you'll know everything there is to know about common outcomes that happen in shoplifting cases in Florida. So what are some common outcomes in a shoplifting case, right? Well, again, as we talked throughout this series, if you're charged with petty theft, which is a misdemeanor level of shoplifting, well, there's really two types of petty theft that you can have. So, and it solely depends on the value of the items that they say were stolen or attempted to be stolen. If it's first degree misdemeanor, then that means that they're saying that it was between $100 and $749, and that would be a max sentence of up to a year in jail or a year probation or any combination of those. Now, if it is less than $100, well, then that would be a second degree misdemeanor, which has a max sentence of 60 days in jail or 6 months of probation. Now, what about felony shoplifting, right? Well, again, it goes with value, and specifically when we're talking about shoplifting, usually it'll be, on a felony level, it'll be $750, but it's not going to rise to the level of a higher level of grand theft. So really, we're just going to have that third degree felony, grand theft, which has a max of 5 years in prison or 5 years of probation. Now, how these cases end up depends a lot on your client's prior record, facts of the case, and how good your attorney is, right? And what kind of work they actually do to defend you, whether it's factually fighting, attacking, defending, or whether it's through mitigation as well. And with our misdemeanor charges, the petty theft for shoplifting, oftentimes we can work out dismissal of charges, especially through diversion programs. If it's a first time, sometimes a second time. And when we do, when we have our clients go through diversion programs, it could be a really good situation because it's the only way we can actually guarantee a client a dismissal, that they'll win and be found not guilty, right? And when we negotiate diversion programs, usually it involves an anti-shoplifting course, community service, no return to the store. It could be for a year, it could be forever to that location, restitution if there is any. Most of the time in shoplifting cases, there's not restitution because you're caught right when you leave, and usually you have the goods with you. But if there's a situation where there is no diversion, maybe because you have priors or just the facts of the case, then we have to fight, and we have to take depositions, file motions, fight the case, just like I explained in the previous video. The depositions are where we get to question and confront the witnesses under oath prior to a trial. We might file motions alleging constitutional law violations, and then obviously at the end we may go to a trial. So though these type of, especially misdemeanors, can diverge quite a bit depending on if we can get an easier, cheaper, faster result, right? That's the best result possible, or if we actually have to put this criminal case into litigation. And it's a little similar for felony shoplifting or grand theft. Usually, since these are lower level felonies, there are diversion programs as well, but because they're a felony, usually the diversion programs last a little bit longer. But when we talk about felonies in general in the state of Florida, we have what's called a felony scoresheet. And it's more or less a point system which is supposed to determine the range of sentences that you should get. Now, like everything in life and in law, there's exceptions to the rule, and there's exceptions to the exceptions to the rule. But this level of felony is a level 1 offense, which is the lowest level. It goes 1 through 10. And that only gives you 4 points on a score sheet. You don't need to know everything that there is to know about the score sheet. However, there's no mandatory prison for a first offense. You need 44 points. And this first offense shoplifting will only give you 4 points. So you're a long ways away from what's called scoring prison in this. Now, if you have a few or a considerable amount of priors, I have seen cases where there's maybe a robbery and a burglary in the background, maybe the person has gone to prison before, and with just based on prior criminal history, those and an additional 4 points will easily put you over the 44 points. But those are rare, especially for our clients. But when I was a prosecutor, we would routinely see that quite often. Now, there's many ways to get around the scoring system and get around if you're scoring prison, like we talked about exceptions. So one is to go to trial and win, right? Be found not guilty. Another one is file good legal motions and use that as a way to negotiate with the prosecutor something that's not a term of Florida State prison. Part of those negotiations also could be witness issues, right? A lot of times civilians don't show up. They leave town, they change careers, they don't want to be bothered, or it could just be based on facts of the case or poor police work, or it could be based on mitigation that we've been able to provide. Another way to get around this is what's called a downward departure motion. And that's where we go and we ask the judge and we say, Judge, look, there's some reasons why our client doesn't score prison. We're asking you to depart downward from the Criminal Punishment Code guidelines and give a non-prison sentence, right? And there's a whole motion, a whole sentencing memorandum that we put together. So, we're going to get character witnesses and letters and everything, and it's a big presentation that we make to the judge. And another way to get around that is called the Youthful Offender motion. What that is if you're 21 years old at the time, or less than 21, so anything before your 21st birthday at the time of the case, then we can do what's called a YO, a Youthful Offender Sentence. And if the judge accepts the YO, then the judge can do anything within up to 6 years. And it could be 6 years probation, 6 years, of prison even, right? For people that are scoring 30, 40, 50 years, that can happen in those cases. But usually in these shoplifting cases, we're not going to need to do a YO. But if we do that youthful offender and the judge grants it, usually it would be something less than than whatever your score is, up to a max of 6 years. So that can be very good, a strategic, some strategic example of what we need to do in certain cases. And like I said, at the end, if none of that works, you can always go to trial. Okay. Hopefully this is some great information, continuing on with our series of shoplifting, and you folks are enjoying this. Like, comment, subscribe, follow us, and we love talking to people about this. We give out free strategy sessions where we're going to go in depth and come up with a customizable defense for you and get to know you as a human being. You can always reach us at 754-206-6200.